listening to The Voice of Russia in London with me, Juliet. Court staff in England and Wales have been called to strike over proposed reforms to legal aid. The Ministry of Justice wants to slice £220 million from the annual budget for criminal legal aid by implementing a model of price competitive tendering. This means the right to choose a solicitor will be lost. Instead, legal representation will be allocated on a rota system by companies like G4S, Tesco or Eddie Stobart Haulage. The Law Society estimates that 650,000 cases a year won't qualify for legal aid in the future. And the Bar Council, which represents barristers, says the plans threaten a world-renowned justice system. So what will be the price of justice in England and Wales, and what legacy will these proposals set out by Justice Minister Chris Grayling have on the British legal system? To discuss this, I'm joined in the studio by lawyer and chair of the Bar Council, Maura McGowan QC. Chloe Setter, Advocacy Officer at ECPAT UK, an organisation which works on the issue of child trafficking and exploitation. Ben Harris-Quinney, who's chairman of the Bow Group and director of Conservative Grassroots. And Robert Oxley, campaign manager at the TaxPayers Alliance. First of all, I'm going to ask you, Maura McGowan QC, could you explain the reforms that Chris Grayling has proposed and what we are expected to see?
Well, the current proposals set out a model for solicitors doing legal aid work in criminal cases, which is called price competitive tendering. There are currently about 1,600 firms doing criminal work across England and Wales. Some of them are large firms, some medium-sized, and some just tiny one-man bands. The plan is that 1,600 firms will reduce down to 400 firms. They will bid for the contracts to do criminal work in certain geographical areas, and the person winning the bid is the person who bids to do it for the lowest price. So the plan is to save £220 million on criminal legal aid, but that's the way that they propose to get there.
But what will this legacy of cost-cutting have on the legal system in the UK, as you see it?
Well, our main concern is that it will drive quality down. We understand a desire to save money, and we fully accept that there are inefficiencies in the system which can be looked at and can be made to work better, more cost-effectively. But driving quality down to what we fear is an unacceptably low level will not simply disadvantage people accused of crime, but it will disadvantage all of us. We are witnesses, we are potential victims, we may sit on a jury. We all have an interest in criminal cases being done properly, and we fear that this will just reduce the level too low.
Robert Oxley, I'd like to come to you next, the campaign manager at the TaxPayers Alliance. From a tax and efficiency perspective, what are your thoughts on the proposal to cut £220 million from the legal aid budget?
Well, look, I think there's an incredibly strong case for reforming our legal aid system, both in criminal legal aid and civil legal aid. And we've seen the civil legal aid proposals go through, and now we're looking at the criminal proposals. The fact is we cannot ignore the fact that we are spending far more money than we have coming in. We continue to run a deficit, and public spending must be restrained. But I think there are deep concerns that the current proposals that are put forward won't actually end up saving taxpayers' money and will limit our access to justice. So I think the guests who will give you scripture and verse about how potentially some of these proposals could actually mean that people end up pleading guilty because they simply can't afford the right legal aid, or that trials don't work properly. I think that is a very valid criticism. But what we need to see then is, as if the government are getting it wrong with these current proposals for criminal legal aid reform, we need to see an alternative, because we cannot ignore the huge cost of the legal aid system, a cost which has not gone down despite the fact that the number of crimes have reduced. And so there has to be some movement on this system to ensure that taxpayers, families who are struggling to pay their own bills, are getting value out of the system. What the government putting forward at the moment, it might not be a good deal for justice, and it certainly might not be a good deal for taxpayers.
Robert Oxley there from the TaxPayers Alliance. OK, Ben Harris-Quinney, Chairman of Bow Group and the Director of Conservative Grassroots. What do you think of the Justice Minister Chris Grayling's reforms?
I'm against these reforms, not because it makes a good system bad, because it makes a bad system worse. And actually, I think there are reforms in other areas of the justice system in the United Kingdom that are more sorely needed. It's an incredibly inefficient system. But legal aid is actually the last place I would begin, because justice in the United Kingdom is expensive. It's becoming more and more expensive. That doesn't just mean that justice is only available to people on a reasonable income. It means that justice is only available to the very wealthy. I think actually the civil system of justice in the United Kingdom is worse than the criminal system, but we are moving down the same line, whereby only those with significant sums of money that are able to fight these cases will move forward and fight them, and everyone else will be forced to engage in a plea or perhaps even plead guilty when they aren't. Of course, this applies mainly to misdemeanor cases or in civil law cases where perhaps people have been defamed or libelled that they just won't pursue because they don't have the money to do that. I think that's very bad. And in terms of how this system moves to the lowest bidder in terms of the provision of justice, I think that fundamentally undermines our justice system in the United Kingdom, which has in the past been based on parity. And there are actually some very good lawyers up until now that have been providing legal aid, in many cases from the very best law firms in the country. And the fact that will no longer be available to the average person, if you like, I think is a major step back. However, I would be open to reforming the entire justice system, looking at the whole thing holistically, and perhaps transitioning to a system similar to the United States, whereby people have legal insurance, or it's much more common to have legal insurance, and also the system of compensatory damages, which is covered in really punitive damages in the United Kingdom, is more significant. So if people do, for example, break the law in either civil or criminal terms, there's actually huge cost implications for them, and I think that would be a great deterrent, and it would actually protect the average citizenry.
Rather than just sticking to the defendant now, let's get a victim's perspective, and that's why, Chloe Sessa, you're from ECPAT UK. What legacy do you see as a charity which helps victims of trafficking and child exploitation? What legacy will this have on those people?
What we're particularly concerned with is that it will create an inequality between the state and those who are subject to its power, in particular children, and even more so for those children who are victims of abuse or exploitation, who already have distinct barriers to having their voices heard and to accessing justice. We're particularly concerned about two elements of the proposals, which is the residence test, which proposes that in order to be able to access legal aid, you have to have been lawfully present or lawfully resident in the country for a 12-month continuous period. Now, we believe that this completely goes against the principle of making any sense when it comes to trafficking, because it's ridiculous to say that children who've been trafficked will have been here lawfully resident because they've been trafficked here against their will. So to deny them access to justice as a result just seems completely immoral and nonsensical. But we're also very concerned about the changes to do with judicial reviews, which is essentially a safeguard that allows us to hold public agencies to account when their responses are inadequate or they're acting unlawfully, which unfortunately we do see is a common occurrence when it comes to providing support and assistance for children who've been trafficked in this country.
Maura McGowan, how will the barristers then be trained in dealing with these cases? Will they be a barrister with experience, or can it be anyone practicing? What will this happen with this competitive tendering process?
Well, the tendering process is for solicitors, not for barristers. But what it will mean is that because solicitors' firms will have to do more and more by virtue of volume just to keep their profit margins up, or to make any profit at all, frankly, the pressure will be to have people who are less qualified, less experienced, doing more and more of the bigger, more serious cases. And because they're doing more and more, they will have less and less time to prepare. So we worry that, as has already been said, it's a system that isn't quite perfect. but we worry that the quality will be reduced below an unacceptable level. But can I just come back on a couple of points that were made before? First of all, there has been a fall in the cost of criminal legal aid. On the government's own figures, it's 1.14 billion 2011-12. The proposed budget for the Legal Aid Agency 2013-14 is 941 million. So that's a drop of almost 200 million, based in large measure on the fact that there is a fall in the rate of crime or detection, but in any event there's a fall in the number of cases going through the courts, and that fees have been cut by, on average, 14-15% over the last few years anyway. The other thing to bear in mind when one looks at it purely in economic terms, cost to the taxpayer, the legal services industry, as it's become referred to recently, brings in 1.6% of GDP. Now that's a massive influx of cash into this country, based on commercial litigation by and large, but not exclusively. And lots of people litigate here, particularly over the last few years, lots of Russian people litigate here because they trust the system, they think it has integrity, they think it has skill and excellence. And that in part is based on the reputation of our criminal justice system as well. To take Ben up, I think he's absolutely right to call for a holistic approach. We are strongly trying to persuade the Ministry of Justice to look at this scheme as a whole and not just put a sticking plaster on the bit that they're not very happy with at the moment. They want to look at the administration and the resourcing of courts. They want to look at the structuring of fees. They could do all of that together, not in the 3 months that they've allowed themselves, but a bit longer. And I'm not trying to kick this off into the long grass, but it does need slightly longer, slightly more mature reflection. And given that the costs are falling anyway, we would think that this is now the time to stop, take a step back, and review the whole system fundamentally.
You're listening to The Voice of Russia in London with me, Juliet Spare. We're discussing the cost of justice in England and Wales after government proposals to cut legal aid. I'm joined by lawyer Maura McGowan, QC, Chloe Setter, Advocacy Officer at children's charity ECPAT UK, Ben Harris-Quinney, Director of Conservative Grassroots, and Robert Oxley, Campaign Manager at the TaxPayers Alliance.
One of the reasons we have so much money coming in from legal fees is because Britain has become the liable capital of the world, and I don't actually think that's an envious point, and that's one of the reasons why we need our libel laws reformed. But it's right that the Ministry of the figures for legal aid are coming down, and we are very much talking about criminal legal aid here. There's another debate to be had about civil legal aid reforms, which I find it easier to support than what is going on in the criminal legal aid system. I think the Ministry of Justice does need to get a grip of its budgets. The fact is, as a department, it's consistently taken its approach to the spending cuts very poorly and hasn't always provided value for taxpayers' money. You can just look at the way it's dealing with, say, the Citizens Advice Bureaus. It isn't taking the right approach to legal aid reform. But what happens is when people who do oppose these reforms, and I completely agree with many of those oppositions, particularly in the access to justice areas, the best thing that they can do is to engage with the Ministry of Justice, and hopefully the best thing the Ministry of Justice can do is actually listen genuinely in these consultations rather than using them as a paper exercise, to actually work out ways that we can make our legal aid budget work better for those involved in it and better for taxpayers. The problem is there is a mixture of opposition here. There's those people who have carefully looked at the system and can see how it is going to create issues about justice. But there's also a slightly snooty opinion, the fact that Eddie Stobart might be involved. The fact that Eddie Stobart, who does trucking in this country and who's kind of not famous for the legal things, the fact that he's involved shouldn't be an issue. The fact that there'll be a reduction in choice and this might lead to people pleading guilty simply because they can't afford not to should be an issue. But I think what also happens is that when looking at legal aid reform, that the criminal legal community have to take a responsive attitude to this, because we can't have a situation of pretending that the status quo is completely acceptable at a time when everyone else is having to see budgets tightened. They're having to work out where they can actually reduce waste, reduce spending. Ministry of Justice and the legal aid system should be no exception from that. So I think it is about having an open, honest debate about how we address the fact that legal aid does place a burden on taxpayers, and that there have been times when it has got things very wrong, particularly in criminal cases, and where the public have been deeply unhappy about the way it has got wrong.
Who needs to be sending out the right messages to those who, the taxpayer themselves, who need to understand the changes and what's going on?
It's an incredibly complex debate, so it is very difficult to get your head around it. You do need to be a QC or a head of the Bar Council to actually understand what's going on with many of these reforms. I think the fact is that for too long the Ministry of Justice and politicians have delayed actually seriously addressing the fact that we have been spending far more cash than we can afford to. And so I do think that this is an area that has to be looked at. But
do you think 3 months is too short a time, too long?
I think the problem is that we've seen in a couple of cases that government have put out consultations and they've simply failed to take note of what has been said in those consultations. Those putting forward and those opposing these changes, the best and most effective way that they can ensure that something good comes out of these reforms is actually not only just to oppose them, to put forward alternatives which clearly deliver the savings that taxpayers need, show how the budget can be made better, show how we can make the system better, without just broad blanket opposing any reforms that come in.
OK, I'm going to ask all my 3 guests here to respond to you because they all nodded or shook their heads at different moments. But I'm going to start first with you, Ben Harris-Quinney.
Whilst it is too much to expect of the average taxpayer to understand the full complexity of the debate, this country is underpinned by a fundamental principle of freedom under the law. And freedom under law means for everyone, for every citizen of the United Kingdom. And when we've talked about this being a great place for people to pursue justice or the libel capital of the world, and also talked about it in the same sense as being a tax haven for oligarchs that want to pursue that sort of justice, that makes the point very clearly that it's the best place to pursue justice in the world if you are very wealthy. And I think there's a real problem with that in the case of in civil cases, but I think there's what's happening is the criminal justice system is moving closer to the civil justice system in the sense that it will be for the wealthy. I think actually the civil justice system shouldn't be for the wealthy, but the criminal justice system certainly shouldn't follow suit. And most taxpayers do understand that fundamental principle of freedom under the law, and there should be parity and equality in the pursuit of justice. And I think a lot of people will understand, even at brief reading of this, that is not what is being delivered. And furthermore, we are actually reducing the parity of provision of justice in the United Kingdom.
How much political support has Chris Grayling got for this policy?
There's been a lot of criticism for Chris Grayling because I think he's actually the first person to hold his role since the 18th century that isn't a solicitor, isn't a lawyer. Now, it was Ken Clarke actually that put forward these proposals, who is a QC. So I wouldn't blame too much on Chris Grayling, if you like. But I think what we've seen in this debate is that we're all pretty much in agreement that this is bad policy. And even if it's considered that these reforms are necessary, I think everyone's in agreement that it has been ill-considered and it needs longer to properly consider, and perhaps actually to just pull back from this particular area of justice reform and look at the holistic look at a holistic approach to justice reform.
But what is a holistic approach to justice reform?
A holistic approach to justice reform is saying that it's not just about cutting where you can in legal aid, it's about ensuring that we have a system of justice in the United Kingdom that is equal to all citizens, not just for the wealthy. And part of that is legal aid, but part of that is also ensuring that for example, I mentioned the American system where if a newspaper, let's say a newspaper libeled you, in the United States, that I think they would be less likely to do so because the damages would be punitive in the sense that they might stretch to in excess of millions of dollars. In the United Kingdom, that's very unlikely to happen. So if we switch to that sort of system where major companies are faced with major penalties if they actually libel someone, let's say, I think that would allow a shift towards justice of the citizen as opposed to major corporations. That's
again looking at the criminal defendant perspective, but we need to look continuously at what legacy this has on the victims of crime. Chloe Setter from ECPAT, this must be where you come from.
Definitely. We're very concerned about how children will be affected when they're acting as witnesses in criminal trials. But perhaps more so than that, we're very nervous about how unworkable and impractical these proposals are on the ground level. And we're very nervous that there's going to be a decrease in specialism among lawyers, which we see is very, very necessary in these really complex cases. But because of the way the proposals are set out, we're going to be asking lawyers to take on a lot of financial risk before they take on a case. And we really believe this is going to put lawyers off taking on cases which are particularly complicated, which is often the way for sexual abuse or sexual exploitation or other forms of exploitation. And this will deter lawyers from taking on the cases and potentially leave children without any access to justice. And in terms of the residence test and proving that a person has been resident in the UK for 12 months, we're going to be asking all types of lawyers to be gatekeepers, essentially, for this, not immigration lawyers. So if the child has a community care issue, they've being housed inappropriately in a bed and breakfast, and that needs to be challenged because they're not being kept safe, they might not. We're asking the community care lawyer to decide and determine, has that child been lawfully resident here for 12 months? How are we going to expect the child themselves to prove that? How are they going to have the documentation, particularly if they've been trafficked here? How are they going to prove that to the system when they often don't have any way of proving it? It's going to be literally unworkable on a ground level, and it's going to cause chaos. And it's ultimately going to put children at risk of further harm because they're not going to be able to access justice quickly and access representation in a fair and efficient way.
So what will happen to these children?
Well, they'll have to represent themselves, essentially. This is why it's so nonsensical to us and really, really damaging. We just don't know how it's going to work out in practice if they do come in. But we really think it will leave children without access to justice and with real barriers to having their voices heard, and will ultimately, like I said, put children at risk.
You're listening to The Voice of Russia in London with me, Juliet Spare. We're discussing the cost of justice in England and Wales after government proposals to cut legal aid. Will it help taxpayers save money, or will justice be just for those who can afford it? Maura McGowan, I'd like you to respond to Robert Oxley's initial comments and then maybe go forward from there.
Well, I agree that there's no point in simply saying no to this consultation paper, and that's not what we've done. We've put a 200-page response in. We are continuing to negotiate with the Ministry of Justice. We have made suggestions about savings, about efficiencies. We resist the fee cuts that are being proposed because they will simply make trying to carry on an independent practice as a barrister completely impossible. But what we're trying to do is to show them a way of saying, well, there are savings here, make those savings, and to go back to Ben's point, then take a breath, step back and look at how the system, which I don't accept is bad, but I do accept is not perfect, how the system can be made to work better, not just in the interests of the defendant. That's important. Access to justice for people accused of crime is incredibly important. But as a potential witness, as a potential victim, or just as a member of society that needs and is entitled to see a criminal justice system that works properly and efficiently, we've all got an interest in this. I know lawyers are accused of having vested interests. And of course, it's what we do for a living, so I suppose we do. But as members of society, we have a vested interest in having a system that works well, that protects the vulnerable, whether they're defendants or witnesses or children dragged into the system, and that works in our best interests. And so we will continue to negotiate. We will continue to put forward what we believe are sensible and sound suggestions. We haven't closed our mind to any sort of efficiencies in the system, but you simply cannot have a system which is generally renowned as being very good, driven by cost and no other consideration at all.
Do you think that Robert Oxley from the Taxpayers Alliance had a point saying that people didn't like the reference to it, legal system being sponsored by Eddie Stobart, and there was a snobbery towards it? And you shook your head when he mentioned that the UK was the libel capital of the world, and they say it's the divorce capital of the world. I mean, but you put an argument forward for how much money that actually made for the tax office.
But the argument I'm putting forward is not. I'm not entirely sure how much money libel brings in. It's a tiny proportion of the cases that are run at any time. What brings the real cash inflow is commercial litigation. And it is seen to be, as it were, the good side of what we do in the city. It's improving our reputation as a financial market, which has taken a bit of a battering over the last few years. And people choose London as a place to conduct their litigation, not because of the tax code, in all honesty, but because we provide the best service, not necessarily the cheapest, but the best service based upon the skill, the expertise and the integrity of the system. Now, frankly, if we are producing that sort of cash inflow for the benefit of the entire population, then it seems slightly misguided to run the risk that you damage, as it were, the publicly funded side of the profession, just in order to save. And I'm not pretending that £220 million isn't a lot of money, but in government terms, it's not a vast amount of money. And as I say, we will do our best to find as much as, if not all of that, by way of savings and efficiencies.
Chloe Setter, ECPAT.
Well, I think it's important that we do definitely talk about the cost savings. We have to also think with our consciences as well, and what impact and who will actually bear the cost of these proposals. What sort of society is it that denies access to justice to the most vulnerable people and doesn't give them the tools to be able to speak up for themselves and to hold others to account? By not being able to hold public agencies and authorities to account, that's a really dangerous area to be in, not just for those individuals who are actually seeking to challenge, but for all of us, for everybody. And I think, if these proposals go through, we will be judged as a country for how we treat our most vulnerable in our society. And this, in the context of many other cuts that are happening across the board, is putting a nail in the coffin, essentially, of what is a very fair and free society.
Ben Harris-Quinney, what would your response be, or your final thoughts, really, on Chris Grayling's proposals and what you've heard today?
In a perfect society, the doors of the judiciary are open to all, from the very most vulnerable people, the children that have been trafficked from other countries, right up to the most wealthy corporations. And that is the principle that we have to apply, an even-handed approach to all. Yes, it's important we attract corporations to engage in commercial law from London, but it is absolutely as important that we ensure every citizen has parity access to justice as those enormous corporations. And if we don't do that, then not only have we failed in our justice system, but we're failing as a society.
Maura McGowan, QC, you're nodding in agreement with obviously both Ben and Chloe there.
You cannot judge how you treat the most vulnerable simply by cost alone. There has to be quality. They have to have the same right to a reasonably funded and proper system of justice.
While they might save money, in some ways, where will the leakage occur elsewhere? Someone else will have to pick up the pieces, and as a sector, the NGO sector, the charity sector, is very concerned that we're going to be left with children and vulnerable people who can't secure justice, and we can't get them representation. We're going to have to take on that extra burden, and there's not going to be any extra financial support for those people who are supporting these vulnerable people.
That was Chloe Setter from ECPAT UK, which works on the issue of child trafficking and exploitation. And I'd like to thank all my guests: Ben Harris-Quinney, Director of Conservative Grassroots, Robert Oxley, Campaign Manager at the TaxPayers Alliance, and Chair of the Bar Council and lawyer Maura McGowan QC.